Thank you. Well, good afternoon to everybody. We greatly appreciate you all being here today. Let me just say that we are living in some very unique times, and of course, there's a lot of uncertainty. So as you listen to this webinar, I hope your family is healthy and your business will get healthier. But let me just say, we're here to help you through this very difficult and challenging process. Today, I'm joined by some wonderful people that help me. Again, my name is John Hetwer. I'm the president and founder of Payroll Plus HCM. We're also joined by Jim Engel of Cuesta Bank. And obviously, everybody loves our bankers today. And Larry Shaheen is an attorney for a McIntosh law firm. Our goal today is really to cover some major things that are happening relative to legislation for the employer. Okay, and let me just start at the next slide. Let me just start at the big level. The goal of the federal government, right? The reality is everything we're seeing from the goal of the federal government, it's really to put the entire economy in a deep freeze until this coronavirus passes. Obviously, there are steps they are taking to make that happen. But one of the things they do know that if you're a 50-employee company, and then you drop down to 30 employees and don't bring them back, it will take a significant amount of time for you to go out and train, recruit, and hire, and get up and running to the point you were previously. The alternative is if they could incent business owners to maintain their employee relationships, in that scenario, then when this passes, you bring all 50 people back, and boom, we're off to the races again, and hopefully our economy can run stronger. And of course, the longer it goes, the harder that is. But that's the goal, to make the economy kind of put in a deep freeze, ask the employers to maintain the relationship with their employees, and they're doing things, passing bills to help facilitate that. And that's what we're here to talk about today. First thing I want to talk about, let's talk a little bit about the process. I mean, obviously, all of you out there have a lot of concerns, and everybody wants to, am I doing the right things now? Hopefully, we'll help answer some questions. But kind of here's what happens. Congress passes legislation and President signs it, right? That's a general process. After they do that, it takes a little time for the agencies, right? In this case, the IRS, Department of Labor, SBA, they issue guidance. And they actually tell us, how do we actually administer the law that the Congress just passed? And finally, right, after they pass it, then it gets to us. It gets the attorneys, the bankers, the payroll companies, the HR companies to say, okay, here's how we execute the law so that we can properly educate you on what is the best move for your business. So while we want to know the law is passed every once ago, we are really waiting for agency guidance, right? And we did just get, and Jim's got some really good information. We did recently get some guidance from the SBA. Department of Labor came out with more guidance late last night, and it's just continuing to come through, and there'll be continued guidance as this goes along, okay? So I just want to kind of explain the process so you kind of understand what we're dealing with. Let's first talk about the recent legislation, right? So the first bill that was passed by Congress was called the Coronavirus Preparedness and Response Supplemental Act. We're not going to talk about it much today because, frankly, it didn't affect us. It was really for the medical industry. It wasn't a bill that affected the small businesses. But that's what you hear when they talk in the news about bill number one. Bill number two was H.R. 6201. This is the one that I'm going to discuss significantly today. It is the Family First Coronavirus Response Act, also known as FFCRA. Some people call it the Family Medical Leave Expansion Act, because what they actually did is take the Family Medical Leave law, and then they expanded it to bring it to more employers and to be used for the current times that we're in. It was signed on March 18th. The law said the president it will go into effect 15 days after he signed it. But the reality is Department of Labor came out with guidance, so that would have been April 2nd. Department of Labor came out with guidance a couple of days later, said this law will take effect April 1st. So it took effect, obviously just took effect, right? And now this applies to all public agencies, regardless of the size, and any private entity from 1 to 499 employees. So we're talking to a lot of our customers, and they're saying, hey, does this apply to us? Yes. If you're 1 to 499 employees, it applies to you. And, of course, all the public agency as well. Next slide. The final bill we'll talk about is the bill that Larry's going to cover, and that's probably why a lot of you on the call today, it is the CARES Act. This is the $350 billion business package, but the total stimulus was $2.2 trillion. It passed on March 22nd, so it's not even a week old, though it seems like it's a month old in a lot of our minds, and it was effective immediately. And actually, it was retroactive to February 15th of 2020. And so, next slide, please. So that Larry's going to talk about that a little bit in a moment. So let's first talk about the FFCRA, okay? But before I do that, I want to talk about some terms that you might not completely are familiar with, or you don't know the discrepancies, okay? So we're going to talk about furlough, layoff, and reduction of force. A furlough is a temporary period where you have short-term unpaid leave. And in that scenario, you are not terminating your people out of your accounting package. You are not terminating for the sake of paying out sick and vacation. You are not doing any of those things. They are still your employees. They're yours. The only difference is you're saying you're not working today. So it's kind of like if you when you worked in high school in the staff, you'd look for your schedule. It's kind of like you're still on the team, but you're not scheduled. Okay. The main thing with the furlough is you continue benefits without pay. Now, in the early days of the FFCRA, we thought that if you were furloughed, you would still be eligible for FFCRA. However, if they later came out with guidance that if you are furloughed and you were furloughed prior to March 31st, FFCRA does not apply. Now, for completeness, the next piece is the layoff, and that's when the employees are terminated, okay, and there's a complete separation of the company. And you might say, you know, business is bad, we're going to lay you off. We hope to bring you back. We do recommend you don't promise to bring them back just because you could run afoul of some HR legislation, but you just say, our goal is to bring you back. You can say, our goal is to bring you back when things improve. It's no commitment to bring them back, but in that scenario, you are separating them from the company. You are required generally to pay their sick and vacation out if they had any. Okay, and then of course the last one is a reduction in force. That means, I'm sorry, we've eliminated your position. We really appreciate your efforts. You're no longer employed with the company. So I wanted to get those clear. The important thing with the furlough is you continue to pay their benefits, and the government wants that. They want you to keep the hooks, for lack of a better word, in your employee. They want you to really maintain that relationship so that when this passes, all your employees come back, you're all back to full force, and the economy starts kicking again. Now, one thing for you people who are involved in benefits, you may say, well, John, they have to work 30 hours in order to keep health insurance. I can tell you, I would recommend that you check with your individual health insurance companies. I can tell you that North Carolina Blue Cross Blue Shield did come out with a ruling that said, because of this very special time, we are going to waive that you must work 30 hours, and as long as you're paying the premium, regardless of the hours of work, benefits will maintain intact through 4/30/2020. So that leaves the end of all next month, that even though they're not working the 30 hours as you normally expect, they can go ahead and be paid. Next slide, please. All right, so let's talk about the FFCRA. There's really two components. The first part is the emergency paid sick leave. Okay, and basically it's sick leave requirements that you have to pay to your employees. They are paid at 100% of wages. The other piece to that is the emergency medical family leave, and that's when you actually need family leave for a couple of different reasons, and we'll talk about that in just a moment. Now, I'll tell you, I've talked to a lot of some customers that said, John, if I have to pay the FFCRA, I have no revenue, I have no business, I can't do that. I'll go broke. I'm already broke, right? And in that scenario, there is some exemptions for available cases that if paying and abiding by this act could jeopardize the ongoing concern of the company, you can file for an exemption. Okay, next slide, please. So let's talk a little bit about the details of these different things. The first one is really the sick pay, and this is where you're paid 100%. And there's really three main things. Number one, if you're under quarantine order by the government. Now, I think I heard this morning there are something like 27 states, might be higher, 32 states. I don't know. I can tell you Mecklenburg County is under quarantine order. So all those people would be eligible for sick leave after 2 weeks of pay or 80 hours. Okay? That caps out at $511 a day. And of course, it would be 10 days, so that would be, $5,110. Okay? So everybody in Mecklenburg County, and I think everybody, frankly, now at this point in the state of North Carolina, all these other states are following suit, so they kind of fall under this, okay? Now, I'm not saying you go out and pay this. I'm going to talk to you later when Larry gets into the CARES Act. I think there might be a reason why you would not want to take the tax credit, because they're going to give you a tax credit to pay for all this. But we'll talk about that in just a moment. The other thing is that if you've been advised to self-quarantine, then by a medical physician, then of course you're eligible. And of course you're experiencing symptoms, you're waiting for a diagnosis. If we go back for just a second here. Now let's talk about the next one, caring for someone. Now the next one is more of the family medical leave. That is at 2/3 pay. That is caring for someone in quarantine. And that's a 10-day waiting period again, 2/3 of the pay. That's got some lower limits. It's $200 a day or a total of $2,000. And lastly, there's a situation where people have to care for their child. Their child's are out of school. They don't have daycare. So basically, that is 12-week duration, but the first 2 weeks are without pay. So there's 10 weeks of pay to $200. That gives you the total that's shown. Okay? Next slide, please. Now, I will mention the Family Medical Leave Act, or excuse me, the FFCRA, that employers of health providers and emergency responders obviously are excluded from this because if everybody called in sick, then we'd have really big problems. So there are some exclusions in the healthcare industry. Next slide, please. All right, so a couple of final things I want to touch on is there are part-time employees. People say, what do I do with my part-time employees? Well, in those scenarios, you would pay them an average of what they would normally be scheduled. So if they work an average of so many weeks or their schedules for so many weeks, it's not 80, but it's a lower amount. You pay them the amount they normally be scheduled at 100% of pay. In order to qualify, they also have to be your employees for 30 days. So if you hired them today or you hired them a week ago, they would not be eligible until they've worked for 30 days. And finally, as I said, there's a 10-day waiting period. In this scenario, you can, as an employer, elect to use they can allow them to use, hey, use your vacation and PTO to help give you money until that time. You cannot force them to use their PTO, but you can allow them to use their PTO. So that's a decision that you can make because, frankly, you got the challenge of cash flow at this time. We understand that. Now, all this I'm talking about, as you're listening to me, you go, well, I can't afford it. There are some tax credits to deal with that. We'll talk about in a minute. Okay? And then lastly, it's very similar to FMLA. The whole purpose of FMLA it is never intended to be a paid leave. It was always more of an intention of you are required to hold somebody's job. And it went for 50 employees. However, now there's some exceptions. If you're under 25 employees, the requirement for holding their job goes away with exceptions. So I'll just kind of explain that to you. Okay? So let's talk about okay, how do I pay with this? Next slide, please. How do I pay for this? Okay? There is a tax reimbursement that you are eligible for. It's pretty much an instantaneous reimbursement. So as you know, as a payroll company, let me just give you a scenario. Say you have 5 employees out on sick leave. You had to pay them $5,000 in gross pay. But you still have 20 employees working. And when you run the payroll, your taxes, your federal taxes, and mainly I mean your 941 taxes, which would be your federal withholding, the Social Security and Medicare, and the matched Social Security and Medicare, right? Those 5 taxes. Those would come up to, say that comes up to $8,000. Well, you can take an instantaneous credit and only have to pay $3,000 in that pay period. So in this case, you get on nearly immediate reimbursement. Now, there are those of you out there who I completely understand going, but John, I don't have 8,000 taxes. I have 0 employees now, so I have 0 liability. And in those scenarios, that's where you start to say, as a going concern, I just don't have the cash flow, but you should be paying it. Now, as I speak to this, the final thing before I wrap up is there is probably, in my opinion, that Larry's going to talk about, an even better plan that you should take advantage of instead of taking the tax reimbursement plan. And I think Larry explained to you that if you take this one, you're not eligible for the better one. So we wanted to be complete and show it to you, but there's a better way, in our opinion. I think each one of you need to look at your situation and need to say, hey, this is what's best for me. We are happy. We're here to help you. I can tell you, Aquesta Bank, McIntosh Law Firm, Payroll Plus HCM. We want to help you through this. Do not hesitate to call our office. At the end, we'll give you our email address. So as you listen to this email, if you have a question, jot it down. We're going to have a question and answer period at the end here. We want your questions. We want to help you through this. We'll all get through this together. One final thing before I turn it over to Larry is, next slide, please. There is in the Emergency Care Act, the Emergency Paid Sick and Medical Leave Act, all right, the requirement that you have to notify their employees of their rights relative to this act. It is a one-page poster, and those on this call, we will be sending out this slide deck. We'll send out a recording of this presentation, and we'll be sending you this poster. So just want to let you know that's a takeaway you'll have. So with that, I'd like to turn it over to Larry, and he's going to cover a little bit of the CARES Act for you today. Larry?
Yes, thank you, John. Appreciate that. So we're going to go ahead and get started on essentially what is probably one of the largest expenditures, single expenditures in our government's history here over the course of the history of our country. It's a real pleasure to be here today. I really do want to thank John, and I especially want to thank Jim Engel for making the time to join us today. I can't even imagine what him and his staff are going through trying to get a lot of the provisions of this act ready to go. We did this webinar earlier this week. I think it was Tuesday. We're re-recording it today, but I know that they have to go live with these loans on Friday. So that is just unbelievable, the turnaround time, and I don't envy them that. I'm very grateful for their time. So the Coronavirus Aid, Relief, and Economic Security Act details, individually as an act, it's over 800 pages. Like I said, largest single injection of federal money into the economy in the U.S. history. It equates to about 10% of America's total economic output. And there are already discussions. I was on the phone with several congressional offices yesterday. They're already talking about a fourth phase. I would not rely on that, primarily because I understand that there's a lot of wish list items from both sides of the partisan aisle. And I'm not so sure that if this pandemic starts to stem in the next few weeks, that there will be a mood to move into a fourth phase. But from our understanding and from your understanding, I believe, John, Secretary Mnuchin has been very clear that on this specific part of the bill that deals with small business, there's going to be more than enough funding available. So let's move into that. So the part that deals especially with your business, we actually prepared a little booklet. This is the booklet. This is the 241 pages that specifically deals with you and your small business. The first and most important program that you're going to find is going to be the Paycheck Protection Program. That program is an expansion of the SBA 7A loan program to support new loans that will go to your business. Now, Jim is going to talk about all of the details, and I know he's gotten more guidance since we last spoke, but the most important, glossing over the high end, you've got an increase in maximum loan amount to $10 million. You've got allowable uses that are expanded to include payroll wages, which include paid sick or medical leave. For employees that are earning more than $100,000, you have to cap that salary at $100,000. Your payroll costs, health insurance, company provided benefits, including retirement match, mortgage, rent, utility payments, insurance premiums, and other debt obligations. That's all written into the bill. All of those are allowable uses. Now, it's going to be important to remember that just because it's allowable does not necessarily mean that it's going to be forgiven, which is going to be the second part that I'm going to talk about that's in the bill that Jim is going to talk about more of the details. Certain borrowers are eligible for loan forgiveness equal to the amount spent during an 8-week period after the origination date of the loan. Now, it's important to remember that 8-week period. That 8-week period is different than the calculation of your maximum loan. So don't freak out when you're thinking, oh my gosh, they're calculating this based on my payroll. No. They're calculating it based on 2.5 months of your payroll, but you are only going to be required to spend 8 weeks of payroll. That's a very important distinction. They're giving you another month of expenses for your payroll to pay for additional forgivable expenses that are involved in the act. That's extremely important. Now, what can be forgiven? Payroll costs. Interest payment on any mortgage incurred before February 15th. You've got rent on any lease that was enforced before February 15th. Now, here, I know that some folks are probably going to be like, oh, wait, what if I go back and backdate my mortgage to myself or my rent to myself? Don't do that, because what will occur is that if anyone finds out about that, it's going to wind up being a problem. Just leave it exactly the way it is and figure out a way to move forward on that. And again, utilities are the last one that they're going to let you spend money on. That will be forgiven. Treasury came out with guidance on this. There's going to be more information. I'm going to let Jim go into that. But here is the kick in the head. You can't take this program and spend this money on this portion of the program and claim a full credit on the payroll tax benefits that John just talked about. That's important. If you take this program, for the period of time you are covering those expenses, you cannot claim the credit. So you need to make a decision up front. Can I survive these next 8 weeks without potential new revenue and still be able to move forward? If you can, you may want to consider not taking this. If you can't, you definitely need to take it, but it's important that you and your accountant make sure that you go in and work that out once you come back in on the tax credit, because the FMLA expansion goes all the way till December 30th. It does not end at this end week period. That's a very important distinction. And again, if you are considering furloughs or layoffs, you want to hold off on making any of those decisions until you are determined whether you're going to apply for this loan and then whether you're going to get it. Because if you reduce your payroll by more than 25%, you will be reduced the amount of loan forgiveness in a subsequent portion moving forward from that. Now, we're not recommending that you cut your payroll by more than 25%, but we are definitely recommending that you make any decisions on your staffing levels after you've done this loan. If you have already made decisions, you can come back and change those decisions and bring people back and do that reactively. But it's going to be very important that moving forward, and this is just a morale thing, not necessarily a legal thing, you don't want to lay people off, bring them back, not have things work out, then lay them off again. That's just, I think that would be destructive for a business, and it's something that everyone should avoid. Now, what if you have to lay people off? What does that mean? What are they going to get? How can we help them? Well, under the CARES Act, federal government is providing an additional $600 per week in addition to regular state unemployment benefits. That starts on April 4th. Anyone who is laid off in the next 2 weeks will probably wind up having to wait about a week or 2 weeks before they get their payments. They've waived that first week of a waiting period, but not all states have waived it. Federal government has instituted some provisions in there that are trying to incent people to waive it so that the federal government will pick up the whole first week of that tab. But some states like North Carolina have a little more stringent benefits, and North Carolina is well prepared with more than a $4 billion surplus in their unemployment fund. But that doesn't necessarily mean that it's going to stay that way. Look for changes in that to come into the short session of the North Carolina General Assembly, if not in a special session, which they may or may not call. The federal benefits are going to be 13 weeks of additional benefit at $600 a week, which increases the common 26-week max for most states to 39 weeks. So that means that there's going to be more benefits, but the maximum benefit at $600 in addition to that $350 is only going to run for about 13 weeks. So that will end at about the time that most of the Paycheck Protection Plan money starts to end. So strategizing from a standpoint of what's best for your employees, don't lay them off now. You want to hold on to them and pay them through the Paycheck Protection Plan. If COVID-19 goes away and we're able to continue the economy moving forward, they'll never have to go on unemployment. If they go on unemployment now and they start to claim those benefits, that cuts up how much of their benefits they could have taken afterwards if you do have to go back and lay them off. So this is a very important point. You want to make sure that you're trying to maximize the amount you're giving to your employees. That's exceptionally important. And then the last point, which is more of a really kind of a in the weeds business issue, you've got 100% reimbursement for state short-term compensation. States are going to be 100% brought back in, and there's no increase to your business on that. So when hours are reduced in lieu of a layoff, receive prorated unemployment benefits, that will go through the end of the year, and those programs are funded 50%. Now, payments to individuals. This is the stimulus payment, which is in here. Those payments to individuals are going to be determined based on your 2019 tax filing. If you have not filed your 2019 tax filing, they're going to pull your 2018 tax filing. If you haven't filed your 2018 filing, they're going to pull your 2017 filing. If you make anywhere below $75,000 in adjusted gross income, you'll receive $1,200. If you are married and you're filing jointly, your max is $150,000. You will both receive $2,400 for that couple. There's an additional $500 payment that comes in per child. So if you have dependents, and it's very important that when you file your taxes, you handle that from a dependent standpoint. You've got to list them on the actual IRS form, and they have got to be on their forms claiming that they're a dependent of you. Now, that additional $500 will phase out over time if over a certain age. If your kid is at college and he's filing his own form and you're not claiming his as a dependent, you're not getting that $500. So it may be worth it to go ahead and accelerate the filing of your 2019 taxes so that you can get the maximum amount. If this year, 2019 was worse than 2018, that may not be for a lot of us. I know it's not for a lot of folks on this call. 2019 was a very good year, but for some folks it wasn't. You have to make that determination for yourself. In addition, those payments are going to phase out over the time on the income threshold, and they do not go to single filers making more than $99,000. You've got head of household filers with one child. They're earning more than $146,000. You're not going to get anything. Joint filers with no children earning more than $198,000. They are also not going to be getting anything. Now, these are the important tax credits and business tax cuts that are involved in the business provisions of the CARES Act. The first is a tax credit for businesses that are keeping idle workers on payroll if they meet a certain criteria. That's a refund for half they spend on wages up to $5,000 per worker. Again, these are not accessible to you if you are taking a Paycheck Protection Plan loan. You need to consult a lawyer or an accountant to strategize if this is the best option for you. Now, they are delaying the 6.2% employer Social Security tax right now. It's been delayed. So that 6.2% match that you have to make as the employer Social Security tax has been delayed. 50% will be due at the end of 2021, and the remaining tax will be due at the end of 2022. Now, here's some additional tax guidance that just came out yesterday that folks don't know about. North Carolina just extended the tax penalty deadline to July 15th. That's for everything. That's for ABC permits. That's for just about any tax filing you can make. That's a huge deal. Make sure you are keeping track of all that and that you are trying to bring that information in to your decision making. You do not want to have to give away cash right now that you don't have to, and there are a lot of people working to make sure you hold on to your liquidity. You need to survive, and that requires liquidity. So hold on to it as much as possible. Most important, to qualify for these two provisions, you have to show a 50% loss compared to the same quarter in the years past. That is going to be a means test. You're going to have to show that. If you don't show that, it's not going to be something that they take. And again, like we said, there's no SBA loans if they opt for the tax credit. Now, there are a lot of business tax cuts that went into, especially for real estate. There's a big difference there in how you're going to spread those depreciation losses. There's a lot of big credits in there in terms of showing a loss. You've got some increases in what you can do for tax deductions for interest, and expands the ability to deduct losses from taxable income. Those are huge changes in how your taxes are going to be calculated, and you want to make sure your accountant is on top of that. So, yeah, go ahead, John.
Larry, I want to jump in on that last slide. You know, one of the things that you mentioned, we are having a lot of customers that say, hey, I want to take that 6.2% or I want to take that one. And I think that's a very good point that you may really want to not consider taking those taxes because the CARES Act and the Paycheck Protection Program is going to be a much better way to go versus trying to show that, because I would argue that amount, while you do save some money, it won't be probably anything near what the Paycheck Protection Plan would be.
All right. John, you're up.
Okay, I want to cover a couple of things relative to unemployment, because here at Payroll Plus, we're taking a lot of questions on this. And if we go to the next slide, please, is it is important to know, right? A lot of people say, well, I don't want to lay my employees off. And there is a strategy of, do I lay people off? Do I not lay people off? And some of you already have, okay? But North Carolina, South Carolina, and many other states, I can tell you Pennsylvania, I know for a fact, has as well, that if an employer's unemployment, if you file for unemployment, it will be a non-charge to your business. What does that mean? That your tax rate is not going to be affected. In North Carolina, if they pay out unemployment, they generally tack on 20% and subtract it from your account balance, which makes your balance lower, which causes your rate to go up. They are not going to be charging your account. So any of the employment expenses will not adversely affect you going forward. So in the past, we always try to make sure people who get some of our unemployment account are worthy of it. And in this case, it's okay if they're filing. It's not going to affect you. They just need to write COVID-19 in the reason. Why are you laid off? Just say reduction in force COVID-19 is pretty much all they need. Okay. If anybody is having we've had a few customers that have some concerns or challenges. We're happy at Payroll Plus to help you with that. Please feel free to give us a call. We'll do what we can, because they should not be denying these claims unless there's something more that we're not discussing here. So we're happy to get in there if necessary. Okay. The other thing is one of the rules is the employers, as I told you, must provide information on how to apply for unemployment. So that's something else that we give you. Okay. And this is another thing that you need to research your individual states. I know a lot of us here are in the Carolinas. There are probably some people who are not from the Carolinas, some of our clients across the nation. Employees can file an attached claim for the employees, okay? But that is only in certain situations. North Carolina Department of Revenue is kind of recommending, we really don't want the employers to file. We would rather have the employees file, because with an attached claim in the state of North Carolina, after 6 weeks, the employer has to, or employee has to file anyway. And so they're kind of encouraging, just let the employee file right from the get-go. Next slide, please. Larry mentioned this. I just want to reiterate it. The 1 to 3 week, as part of the CARES Act, a 1 to 3 week waiting period has been waived. And the other thing that has been waived is the requirement to search for work. Okay, I can tell you that's waived in North Carolina and South Carolina. It's waived in many other states. If you're not one of those states, please check. So those are three really big things that you need to know when you're looking at unemployment. There is no waiting period. It is not going to affect your rate. And the requirement to search for work has been waived. And again, this goes back to what the entire big picture goal of the government is. And that is, we want you to stay with the company you're at, so when this passes, we all go back to work. They don't want you going to find another job, so therefore they're not requiring you to go search for another job, okay? Because they want you to come back to the job that you already have, that you already know, that you're already trained for. A great website for all the different states, state-specific. You put in the state, it gives you a lot of information right there on the screen. We will send out this slide deck, but you can jot that down if you would. It's careeronestop.org. I believe it is part of the Department of Labor, if I'm correct. So it is a great one-stop spot to look at the rules of all the different states. Okay. Now, finally, I want to share with you, before I turn it over to Jim, something that is a little unique that has inadvertently happened. The legislatures chose not to fix it. It was discussed. They knew it needed to be fixed. It didn't get fixed. It could possibly be fixed in a future bill, or they're not saying, no, we're just going to go with it, right? There is, in some cases, a chance to you're going to double dip, right? So in North Carolina, they basically, I give you an example here. If you take George Wade, Joe gets laid off. His wages in third quarter of 2019 were X. His wages in fourth quarter of 2019 were Y. You add them together and you get that dollar amount, $14,500. You divide it by 52. That is the calculation North Carolina uses to determine your benefit. You see, Joe makes $280 out of that. In North Carolina, the maximum is $350. In South Carolina, the maximum is 326. Okay. However, with the CARES Act, they're going to get another additional $600 weekly benefit. So theoretically, Joe could be making $880 a week being laid off. Now, you say, well, and I had a hotelier mention to me recently. He says, John, he says, my housekeepers, they're not going to call back. If I call them back to work, they're going to be so mad. And I said, you got to remind them that that's a short period. That's going to end, and then they're going to be without a job. And so this is a little bit, it is possible that your employees could actually make more, and you could actually be helping them by laying them off and then bringing them back timely once you get your PPP approved. Because once you get your PPP approved, now you bring them back, and then you can take it and be up to the 75% that Larry was talking about. With that, I appreciate so much Jim Engel, who has given me personally a lot of guidance on this. The big thing that everybody is excited about is the SBA loan, the PPP loan, as we call it, through the SBA. So I want to give it to Jim. And Jim, go ahead. I know you just got guidance from Treasury the other night, so you've been really busy. Give us your thoughts.
Thank you, John. Can we go to the next slide, please? First off, I'm going to talk about two aspects of the CARES Act. Both are very, very significant to small business owners. I will also point out in the slides where there's been changes really from Tuesday to today. These slides were made, and then the government came out with some changes. So this is like hitting a moving target. But that said, there are still very, very significant benefits that I believe every small business needs to take a look at. And when I say small business, that means you have fewer than 500 employees. So for the vast majority of our customers, that certainly pertains. So there's two big aspects to the CARES Act when it relates to small businesses. And the first one I'm going to talk about here, it's an immediate relief. There's no application for current outstanding 7A loans, and it's very little publicity on this. So, and frankly, very little guidance being given exactly how this is going to work. But what this first thing is a 7A loan is a small business administration loan. If you have one, which many businesses do, they do cover almost anything related to a business, everything from an acquisition, startup of a franchise, to just normal lines of credit and so forth, operating lines for small business. And basically what the Act provides is that if you have an outstanding 7A loan, for the next 6 months, the SBA is going to make your loan payments. So that means both principal and interest. The Act actually even says any other associated fees. So if you have an outstanding loan, commencing with the payment due after the enactment of the Act was March 27th, the SBA is supposed to make the payments. Now, as a bank, we are expecting that we'll receive some guidance from the SBA relating to how are they going to calculate on an individual loan basis what is due and how are they going to pay the payments. But we do not have that information yet. We're expecting it basically any minute because many SBA loan payments are due essentially right now, April 1st and so on. So we are looking for that. If you have an outstanding 7A loan, you need to be asking your banker about it and then going from there. Now, I will also add that prior to the enactment of the CARES Act, many banks, including our own, were providing some voluntary relief. For most 7A loans, we were providing a three-month deferral of all their payments. In some rare cases, that was as long as 6 months, but for the vast majority, it was 3 months. That 3-month deferral gets tacked on to the 6-month payment relief by the SBA. So you don't actually lose anything. In fact, you get essentially 9 months without payments. Now, what's really remarkable is that this same 6-month payment relief by the SBA applies to even new 7A loans. So if you go out today and apply for an SBA 7A loan and get qualified for that, then you get the 6-month relief. So that goes up, that program, new loans, all the way through September 27th. We have seen a remarkable reaction to that. Some deals that were basically dead have been revived because of that provision. All right, so and thank you. Next slide. That slide's fine. So the biggest program that you've heard a decent amount about probably is the Paycheck Protection Program. The Paycheck Protection Program is remarkable in that it allows you to receive a loan for basically it's equal to 2.5 times your average monthly salary expense. And Larry Sheehan went over a little bit about what that means in terms of how you calculate the total salary expense. But to the brevity is your salary expense times 2.5 times, that's the maximum loan amount you can qualify for. Now, what's really remarkable about that is that that loan can be forgiven in its entirety if you maintain your payroll. So if you maintain your payroll for the next 8 weeks, you can have that loan forgiven in its entirety. Now, in the meantime, it accrues interest at a very low rate. This slide in front of you says 4%. That is actually now incorrect. The law actually says the rates could be as high as 4%, but the SBA came out on Tuesday night and set the rate at 0.5%. So virtually almost no interest at all, but 0.5% accrues on the loan. The other change is here on this slide, I indicate it's 10 years. Again, that's what the law provides. However, the SBA on Tuesday night came out and said, no, they're going to use a 2-year term. So it's a 2-year term with a 0.5% interest rate, and the loan is subject to forgiveness if for the 8 weeks after the loan is made, you maintain your payroll. Last points here, no bank fees, no SBA guarantee fees, no personal guarantee is required, no collateral is required. Frankly, the application is only 2 pages long and really couldn't be much simpler. So this is a program that really every small business really should be taking a look at. The applications, you can start filing the applications through your bank with the SBA starting tomorrow. If the bank you usually deal with is an SBA provider, they already have their systems in place to do this. We have already started receiving applications that we will be filing tomorrow. The key aspects in completing the application is documentation of 2 aspects. Maybe next slide, please. One is that you need to document your payroll. And so if you are a customer of Payroll Plus and some other payroll companies, they will help you provide that documentation. The documentation essentially is federal tax forms, W-2 or W-3 or 941s that allow us to see or verify the compensation. The other aspect of that is that you only can count the compensation to the extent to any one individual up to $100,000. So any excess over the $100,000 for any one individual does not get counted in calculating your maximum loan size. Let me just see. Covered most of that.
Hey, Jim, I just want to jump in, if I could, to assure you that for our customers out there, right, we have been very diligently into the rules. We are going to be providing reports and doing everything we need so that we can maximize the loan. So the ideal is to maximize the loan, and I know you're going to talk about forgiveness, so I'll let you go. But we'll provide those reports, include everything, exclude everything. There's a lot of different little rules that there's a lot of debate on, but we've spent a lot of time really knowing exactly what needs to be added, what exactly needs to be taken out, so that these so our customers and your customers and all of it, we can maximize the loan amount.
Great, thank you, John. And there's a second importance to that, and that is speed. If you haven't filed an application or started your application yet, you don't want to be the last person to file. And I know Larry has indicated that Treasury is saying that there will be enough funds for this. I believe they will do everything possible to make sure this program does not run out of funds. But to a large extent, why take the chance? If you're one of the early filers, you'll receive funds, and you don't have to worry about that. So good point, John. Thank you for adding that. The proceeds that you receive, so they're 2.5 times your salary, and then you have this loan forgiveness feature. And you, okay, so this is an example of loan forgiveness, but basically you can use those loan proceeds to pay for your rent or mortgage payments, for utilities, and for your payroll. And then what they do is they take a look at how much payroll expense did you have in the 8 weeks following the receipt of the loan. And that is then compared to that, to your loan amount. And if your 8 weeks payroll expense is at least 75%, then you will receive a loan forgiveness. So it's really important to maintain payroll for the 8 weeks following receipt of the loan. If you fall below that number, then the remaining balance, if any, of the loan continues to accrue interest, is still due by you. It has that 2-year maturity. Not super clear, but it appears that that loan will amortize, but it's not very, very clear on that. But that appears to be what will happen after this period is over. And okay, next slide, please. And I think that was it for me.
Yep, I think that's it, Jim. I think the important thing is we are getting the guidance, as I talked about earlier. All this stuff is a moving target because the guidance is coming out. They passed the law, and now we're waiting on guidance so we can react. And so we've got a lot of the guidance relative to applying for the laws. Jim, I don't think you've got a huge amount of guidance for forgiveness yet, have you? Or have you Treasury mentioned much about that?
No, there's almost no information on the forgiveness part. There's been a lot of commentary. The Treasury Department is in discussions. It tends to be with the big banks because the big banks, well, they have full-time lobbyists and so forth. And those discussions got relatively heated in the last few days because some of the big banks are concerned that they're going to have to essentially audit or attest the expenses of where this money was spent, and document the payroll that the application was true and correct. Treasury seems to be backing off that real hard attestation requirements. One thing we did not mention, and it is something we mentioned in a prior video conference, but we are highly recommending that a separate account be established with the funds, and that the permitted expenditures of the rent, the utilities, and the payroll be paid out of this separate account. The reason for that is it will be much, much easier to document that these funds were used for proper usage than if they're commingled with other operating accounts. Yeah, so it's not a legal requirement, but we are very much recommending it.
Well,
and Jim, I'll throw out one other thing, if I could, Larry. Go ahead, Larry. One other thing I'll throw out, and that is, I would encourage a lot of our clients, they work with a couple of banks, and my suggestion is work with the smaller banks, because these great big banks, the Bank of Americas, the Wells Fargo, are getting so inundated with these loans. You don't have quite the pull or quite the ability to follow and everything. I really feel with working with a similar small bank like Aquesta Bank, it makes it so much easier to reach out to the bankers and get this stuff through, because I know you guys are doing a lot of stuff relative to infrastructure to get ready for that. I just want to end on this last thing. The slide's been up. You probably
hold on very quickly.
Yes.
There's a couple of clarifications there that I think are absolutely incredibly crucial for folks. One, Jim, I'm not sure. It's funny. I actually read this in the loan, the bill. You'll appreciate this. When they get to the forgiveness portion, you're actually going to be the clearinghouse first. That's what I'm hearing from Washington, that until a bank says that it's willing to recommend forgiveness, that the SBA is not actually going to even touch it until, or Treasury is not going to touch it until the banks take care of it. And then there was one point that Jim made that I think is absolutely crucial to folks when they're going through and looking at this program. I know you and I had talked about this, John. This is something that folks need to be very much aware of. The Treasury is providing the coverage of fees for this. So anyone listening in on this, if I know that Jim's bank has already issued great guidance on this, and they're not taking any fees, but there is a provision within the guidance that deals with agents. That's folks like me and that's folks like John. We also are not supposed to take any upfront fees on any of this. So we are being compensated on the back end by the federal government and by the Treasury Department. Anybody telling you that you need to pay upfront money for them to help you is breaking the law, and they should not be doing that. And if they are doing that, please do not hesitate to call the SBA or Treasury to tell them they're doing that, because this whole purpose of this is to hold on to liquidity. So that's an incredibly important point that most folks who are on this call, like, well, gosh, this is a lot of information. What do I do? Federal government has set it up not only for you to go to the bank and have the bank do this for you, and the federal government will pay the bank for the work they're doing on the loan. Federal government will also pay agents like John, agents like me, folks who are eligible under the law, to make sure that you have counsel, and that's being paid for out of those proceeds. So that's a point that I think is going to be emphasized over the course of the next few months, and I guarantee you we'll see folks trying to catch folks who are going to be trying to dip into that pool of folks who need this and take advantage of them. I hope that doesn't happen.
Larry, that's a very good point. I had a customer call me yesterday that said a particular CPA said they would do it for $3,500 to run the fee through them and help them with forgiveness and stuff like that. Yeah. I know you're going to do it. At Payroll Plus, we're more interested in just taking care of our customers. So to that end, what we are going to be doing is we've agreed, we've got the payroll data, we've got their information. We're going to make it so it'll be so simple. There'll be no reason why they need to learn all these rules, worry about chasing it down. We're going to offer that as a service to our customer. And again, there's no charge to them because we'll be taken care of as an agent. So I'm not worried about that. I just want to close and we'll open up with questions. We want to leave plenty of time for questions. But Steve Mnuchin said this a couple of days ago on Fox Business. He said this, and we're talking about the Paycheck Protection Plan now. This is a very popular program with Republicans and Democrats, and the president likes it a lot. He said, if we run out of money and this is a huge success, we will absolutely go back to Congress and ask for more money. And by the way, it makes economic sense, he continued, because every person we put through this program, we don't have to pay unemployment. And so, that is a major deal, and I feel good about it. Now, that being said, we do encourage you to act quickly. We're going to be in contact with all of our customers today to help them. We're going to be having the reports and doing the things so that you can respond quickly. Again, I would encourage you to as much as you might want to go to the great big banks, I think there's some power in getting that. This is when the community bank works because they have their pot of money that they'll be able to issue, and you're basically working through the bank. So I appreciate everybody's time today. We're going to open up with questions. So Carol is a person on my staff, and she's got questions that people have sent in and emailed us, and and chat it in. So Carol, if we could open the mics up for you, and then Jim and Larry, if you can come back. And Carol, why don't you go ahead and ask the first question?
Okay, thanks, John. We've received a lot of questions, so we'll just try to get through as many as we can. First question, in addition to payroll, rent, recurring operational expenses such as utilities, health insurance, travel expenses, et cetera, there are large costs associated with the delays to our projects. These costs are these costs for stretching out our projects recoverable?
Larry?
Yeah, no, those costs are not recoverable, but this is the important point of the program that folks need to realize. You need to take the cash that's coming from the Paycheck Protection Plan and use it for things that your cash otherwise would be used for. So for example, if you go in and get this program and you have this cash, make sure that you are setting it aside into the separate account like Jim is saying. You absolutely do not want to commingle those funds. You want those funds to be in a separate account where they can be properly accounted for. So that means that other cash that you have in your business can be used for preserving other projects or pushing other projects down the line. I know for some of my developers, they're trying to extend their due diligence periods and make sure that those are working. A lot of our real estate clients, some closings have gotten pushed off. The most important part about this is to survive. So you're going to want to do cash analysis on all this, and you're going to want to make sure that you've got a situation set up where you're going to be able to have a plan for the next 8 to 12 weeks, and that you are using your cash in the best way to make sure that that is going to be something where you're going to be able to deal with moving forward. Because unlike the economic injury disaster loan, which is the SBA process where there's a lot more uses around that, but that's not a forgivable loan, the uses for this loan are very tight, and you're going to want to make sure that you're not spending it on something you're not supposed to, and you are absolutely spending on stuff that's forgivable.
Thanks, Larry. Carol, before we jump to the next question, if we could hit the final slide, we did put up the information of all of us. There is all of our names. There are our respective phone numbers and our email addresses. As you can imagine, our email box is filling up pretty fast, but we want to be here to help you through this. We want to give you the proper guidance. We're not going to tell you everything you need to do, but we're going to tell you here's the parameters, and then you need to make it the best business decision for you. I think a lot of us here on this call, as we've looked at the Paycheck Protection Plan, that seems to be the most advantageous way to go for most of our clients. But again, that does not mean all of our clients, just for most of our clients. Carol, let's go ahead with the next question.
Okay, when would it make sense to lay someone off versus paying them using the FFCRA funds?
Well, I'm obviously, and Larry, I'll let you jump in after that, right? And maybe we can have a little bit clarification, because Larry, the forgiveness piece is at the point after 8 weeks, right? Don't they look at your pay after 8 weeks, and that determines whether it's forgiven? So as long as
I'm going to ask Jim to come back, because I want Jim to make sure to be following along with me here on terms of payroll. Jim, unless I'm wrong, and you tell me if I'm wrong, there are no prepayment penalties to this. So say you get 8 weeks down the line and you are, now remember that the way they're determining payroll is the reduction is based on full-time employees. So they're not actually going to be looking at the total amount you've reduced. It's going to be whether or not you've only cut 25% of your full-time employees. Is that right, Jim? Oh, you're muted, Jim. There we go.
All right. I'm sorry. So it appears that they're not looking on an individual by individual basis. They're looking on your total payroll expense.
Total payroll expense?
Right. And obviously excluding the excesses over 100,000. But it appears to me when I look at it that if you have laid people off but bring them back, and so that your payroll expense in the 8-week period is at least 75% of the average of what it was before, then we're going to end up with a complete forgiveness of the loan. I think it's an interesting, but if you think about it, it makes a lot of sense that they want you to bring people back anyway. So they're going to have to pay one way or the other. They're either paying through the unemployment insurance or they can pay this way. So I think they'd rather keep the businesses alive and together. I think John early on says putting companies in a deep freeze. I like that terminology because it's better than the alternative I've heard was they're putting everyone in a coma. So I think the deep freeze is better. I like that. And yeah, so it's pretty flexible. And I'm not really sure. It's hard for me to see reasons why you would not do this unless you just don't qualify. And I've actually had customers not qualify because their business has not been hurt by CV-19. And I know that's very odd, but there are some businesses that have not been hurt, and they will not qualify. You have to attest to the fact that you were hurt.
Well, Jim, and you'll find this interesting. While I was going through I actually was flipping through the pages to make sure, because I thought I remembered something. You're going to appreciate this. On section B, which is dealing with the forgiveness on page 41 of the loan, read forward. They're actually calculating the reduction not just based on payroll cost, but also on reduction in number of employees. So it's odd because there's actually a quotient obtained by dividing the average number of full-time employees during the covered period, and they're actually calculating the average number of employees and then doing a reduction based on reduction number of employees.
Well, I think the important thing, Larry, if I could jump in, the important thing is what I said at the get-go, and that is they want you to get back to full force. This program incentivizes you to get back to full force. And so while, as I talked to Otelio recently, they said, as soon as I get the loan, I got to bring them all back? No, I said, you can ramp them in as your business needs to, so that at the time that your 8 weeks ends, you're back and running at full steam. And let's be honest, right? A couple of weeks ago, when this passed, we were thinking 8 weeks would be plenty, right? Because that was when the Easter goal was still there. And now we've just lost another month that we're down to out to 430. And so I have a fair amount of confidence from the things that I'm hearing that they're working on number 4. I know we got the partisanship and that stuff we have to deal with, but I really believe if this goes further past 8 weeks, as I've had some customers ask, going, well, what if I'm in the same spot 8 weeks from now? Well, my gut feel, and again, we're just issuing our suggestion because we're waiting on guidance just like everybody else. I would presume that they would extend it, but again, we'll just have to wait and see.
I would hope so. And I think at this point, the guidance to employers should be, don't cut your employees, cut their payroll. Don't lay individuals off, keep them on the payroll based on what your year-to-date average was monthly from the time the loan was made going back a year. But then don't reduce number of employees because they've got a weird quotient in here that's going to mess with that. I would instead, if you are going to cut things, cut salaries by 25% based on the language here in the loan, so that you are not seeing a reduction, because there is no amount in here that states that you can cut any number of employees and still be forgiven. It looks like if you cut any employees, there's a quotient that's going to reduce the forgiveness amount, but if you cut payroll costs by 25%, it's going to be forgivable. So I think that's probably going to be the guidance we go with for businesses, and that's probably going to be hopefully the best way, and I think the way the SBA and the Treasury is going to treat that.
Right, and I think everybody's got to spend their money how they best see fit for their business too, because in worst case scenario, if you don't use that money for forgiveness, you pay it back, right? You give it back to them, But I understand what you're saying, Larry. I think we have to be clear. Is this is moving. We're giving you the best information we can. We are getting guidance, but we don't have all the facts relative to forgiveness. That's the part of the reason that as agents that we will help you deal with that on the backside. And the banks will help you some. The banks are going to have their hands full. We are going to be consulting with our customers of how the best way to handle that. So let's jump to the next question, Carol.
Are commission W-2 employees treated the same as hourly and salaried employees for the calculation of the loan payment, the loan payout? And what about 1099?
Yes, they are, and you are going to have to produce the commission information and the 1099s. Jim, you all are requiring individual 1099s, right?
Am I still unmuted? That's good.
No, yeah, you're good.
No.
Okay. The individual, I think we were looking at 1096s. Is that right, John? The
Yeah,
1099
well, you
reports up into the 1099, the independent contractor ones there's like a week delay in terms of filing applications between independent contractors and C Corps or regular businesses. But you're referring to the independent contractors who are treated, they're essentially part of the payroll for an operating company.
Yes.
Yeah, and I think that's the issue. What I'm telling our customers, for instance, we might have a company that has 30 employees, and they have 3 or 4 1099 contractors. And my understanding is, if those 3 or 4 independent contractors are integral to your business and part of your business, then of course you can include them in your monthly calculation. However, if one of those 1099 contractors was paid because you paid a 1099 contractor to paint your building, right? Obviously, that wasn't included. I think that.
Yeah, the services are excluded.
Right.
Yeah.
So it is interesting. I mean, Larry's brought up a couple of really good points in terms of maintaining the head count, which really doesn't get much publicity in this document. And so that's something we're going to have to make sure we are accounting for on the front end too, to make sure we have the right head count on the beginning and the ending numbers.
There is a single number of that head count, and we're trying to discern what number is that. Is it today, or is that? I've heard a number in the bill of February 20th was going to be their head count number, for lack of a better word. So, but we'll get more guidance on that. Carol, next question.
Is the forgiven amount taxable?
No. No, it is not.
Okay.
Yeah. Fully tax free.
How can employers under 50 employees opt out of complying with the FFCRA?
I haven't seen the guidance of the exact way to do that. Larry, have you seen that? I mean,
Yeah.
I'm not sure. And I did see something going, do not send that to the Department of Labor, which I thought was interesting. I read that somewhere.
It's wage. It's the Division of Wage and Labor, and I will get that information. Hold on one sec. Opting out of FML.
Larry, why don't we just send that out with the
We can send that out over
recording?
email. Yeah, because what you're going to need, because there's because Department of Labor does not want you to send it to them. You're going to want to send that to a separate group, and I believe it is the Division of Wage that's dealing with this, because there's an FMLA section that's going to be making sure that you've got that. I mean, you've got to post your notice. I mean, no matter what's going to happen, you absolutely have to post your notice. But you can opt out, and we will get that contact information for folks so that they can get that information to their folks.
Okay, Carol, next question. We're going to try and be succinct so we get a lot more questions in if we could.
Okay, are we responsible for distributing the employee rights poster to employees via email if we're temporarily closed?
I would recommend, from an HR standpoint, if you have email addresses of your employees and they're not coming to work every day because you are closed, that's a very easy lift to get the email out to your employees so that you're well covered.
John, I'm going to drop off
you could
now. I apologize for that, but I need to drop off now. I have something that's come up. So thank you for having me. I really appreciate it.
Thank
really
you.
a great program. So thank you so much.
Thanks a lot, Jim. We appreciate all your help.
Okay, bye-bye.
Okay, Carol, we'll go for a few more minutes here. Why don't you, any further questions?
Okay, there's an employee who has been off work for 10 days prior to April 1st due to a school closing. Have they already met the 10-day waiting period, or does the clock start ticking on April 1st for the 10 days?
The clock starts ticking on April 1st. For all practical purposes, on March 31st, there was no law. And so on April 1, the law starts, 10-day period starts that day.
Okay. If your company's an essential employer and you have someone that chooses not to work because they're concerned for their health, how should they be handled?
Larry, I'm going to give that to you. I've had that question, I bet, a half a dozen times in the last 3 days.
Yeah, this is where I think it's important to understand the differences. If you're an essential service, you're not quarantined. If you can let them work from home, I would allow them to work from home, but I would make sure that you're keeping track of what they're doing. But I'm going to be a little more technical on the construction. Nobody has technically been quarantined. So I don't think that part of the FMLA standards are covered. They have not ordered people to stay at home. They have allowed essential businesses to open and asked that they work from home as much as possible. But if an employee is essential to coming in to, if they can't do their job from their work, then I would consider putting them on furlough. Because at that point, it's like, look, you've got two options. You can either come in or you can't come in. It's going to be individual based on each employee and employer's need, because there is going to be a lot going on around this. And I know for a lot of folks, yeah, you may not want to come in, but you know, if you're an essential business, the government has essentially said you've got to stay open to keep the economy working. So unless you've got an infected family member, you're sick, you've got family that's sick, you can't have child care, or you can't, or the schools are closed, but even if the schools are closed, you can't get other child care. If you don't fall within one of those categories and people are just generally scared and don't want to come into work, I feel for them. I think that's a real scary proposition, but at the end of the day, there's no part of the act that says you're scared and don't want to come in. That doesn't apply in any of those categories. It only applies if you're on quarantine and your business has been shut down. If it hasn't been, then you gotta go to work.
Well, Larry, this falls into some of the stuff that we talked earlier. You know, I mean, when the governor said, you said that they're not quarantined. I'm gonna do some more checking on that because I've been on a number of webinars myself, and a lot of people say, yeah, when the governor, maybe not the first one where it was the kind of optional, but now then it's when he shut down all businesses unless you're essential, and you shouldn't be on the road unless you're doing X.
Yeah,
and I've heard in enough places that does apply to FFCRA.
See, I think there's a distinction. If you are one of the businesses that was shut down, restaurants, not hotels, massage parlors, haircuts, barbershops, yes, those are quarantined. But if, like, for example, our law firm, you can see from behind us, you're open, John, we're open. If you can't do your job from home and you have to come into work, technically you're not quarantined because you're an essential business and you're allowed to stay open. So I am of the opinion, and I would argue to the Division of Wage and Labor, look, I got to have him here. And I understand.
Well, and
I think that's, yeah.
I think the real clear thing is the big distinction is, are you an essential business or not? And then that helps dictate.
That's the distinction. That's the distinction.
If you're not an essential business, then I think you meet the status of the law. If you're an essential business, I don't think you do.
Yep.
So I'm agreeing with you on that. Next question, Carol.
Yeah.
Will the CARES Act apply to businesses that have been open less than 12 months? And if so, how young can you be and still take advantage of the loan?
Larry, I'll jump in on that. Is the calculation for the monthly wages is fiscal year 2019. It's a calculation. You include the 1099s, you take out certain things. We've got all that wired, okay? If you are a brand new business, you use January 1 to February 29th. If you are not in business in 2020, you are allowed to use those 2 months to determine your monthly wage. Okay. If you were in business, I had talked to a customer. If you were in business in 2019, you cannot use the January 1 to February. I got a customer said, John, but I've really grown a lot, and my wages are a lot higher in 2020 than they are in 2019. Well, unfortunately, you were in business in 2019, so you need to use the yearly wage. Would you agree with that, Larry?
Yes, I believe it's the average for the year before the loan's made. So they can use all the way up to March and use that average. If they've grown in the last 3 months, that'll be reflected in that average. But it's going to be really important that folks understand that you've got some options here. If you were far more heavy loaded on payroll in that period from February to May, you can elect that. But if your average over the last 12 months is higher than that period, then that's what you're going to want to do. There is an election process that folks can use. And again, John, I'm going to pitch to the people listening. This is why you talk to a payroll company or a lawyer or an accountant, because you've got to understand what you can and cannot do, because you're going to have folks say, no, it's only going to be this way. Well, no, that's not exactly what the law says. So this is, it costs nothing for someone to get counsel on this loan. Please get counsel. I don't care if it's us, John, another firm, somebody else. Don't do this without making sure you've had somebody look over it, because it's free.
And you got to understand too, the banks are scrambling, right? Jim jumped off the call because they're scrambling, trying to make sure their infrastructure, they're just getting guidance. And I'll be honest, the guidance is changing, right? 2 weeks ago, if you asked me if you furloughed somebody, do they get to be CARES? I would say, yeah, they're still part of CARES because or the FFCRA, because they're part of your business. Well, the Department of Labor came out with guidance and said, we have determined that if you furloughed them prior to 3/31, they are not part of FFCRA. That was a complete, I don't want to say reversal, but it was a complete guidance change, contradicted what a lot of HR people were thinking prior to that point. And that's going to happen. We are trying to give you the most up-to-date information that we have at this point in time. Next question, Carol.
Are payroll service provider fees eligible for employer costs for the CARES Act?
Larry, I don't know about that. That's considered a fixed cost. And then maybe that's a bigger question. Are fixed costs permitted? Because that's a fixed cost. Are fixed costs permitted?
No, they're not. And that's actually the part again, this is going to be where it's written into the law as to the parts that are forgivable. It is not one of the forgivable expenses. So again, you're going to want to determine why. This is why you isolate the cash from the CARES Act. You don't spend that on payroll money. You instead spend regular money on that, keep the amount back, and then you want to hold on to that money and only spend it for forgivable uses in the 8-week period. Because what you're going to want to do is make sure that you leave money in there so that you can pay it back, so that you're not stuck with a 0.5% 2-year loan. You can use that money if you choose, but it will reduce the amount that's forgivable. So this is why, again, no fees can be a part of the origination of the loan. Once the loan's done, that's not ending. There's compliance that's required on the back end. So pay for the compliance out of your cash, and then use the cash there to either pay for forgivable expenses or give it back. That way you're not stuck with the loan if you are trying to maximize the amount that you want to forgive. If you don't care about being forgiven, spend it on whatever you want.
And I think Larry and I are both on the same page. We're here to help you. We're going to monitor these changes. I promise you, it is going to change. There's going to be things that we said today that the guidance will come out and could contradict us. We think we're pretty darn accurate because we've worked really hard to be right. But things are changing, and we will just change with it. And we will, at Payroll Plus HCM, we will be notifying our clients at each change so that they know, and we do our job to help them, because we really feel we want our customers to focus on what they're doing. They've got enough. We'll handle this for them. Next question, Carol.
We are an LLC, so partners get guaranteed distributions. Are these counted as salaries?
As long as it's not in excess of $100,000 and it's considered a wage. And that's going to be up to the individual banks to determine, and you're going to need to make sure that that's what you're trying to do, that you've got somebody advocating for that on your end, because it's going to be, each bank is going to be determining that differently, because they're going to be the ones who are going to be up front. The SBA is just going to look at them and say, how many full-time employees do they have and what's their payroll? If the banks count those as payroll, then you're good. The Act does not specifically state. They are very flexible on their other wages statement, because it says salary, wage, commission, or similar compensation. If your compensation is a small salary with an additional disbursement that comes out as a distribution, as long as it's not in excess of $100,000, I anticipate that should be considered wages, but it's going to be determined by the bank.
And Larry, kind of a tie onto that, if you're an LLC, as many business owners do, they don't take oftentimes a regular recurring wage. They might take their distribution when there is money available. Okay, so could they then take their money available over that 12-month period of last year of what distributions they took and possibly apply for a loan for that?
Well, and that's where, again, this is where the language of the loan the language is important. Sum of payments, and this is for folks who are self-employed or in an LLC or something like that. The sum of payments of any compensation to or income of a sole proprietor or independent contractor that is wage, commission, income, net earnings from self-employment or similar compensation, but it's not more than $100,000. So that should be covered.
Okay, Carol, last question.
Okay.
We'll appreciate everybody listening. There's so many questions here. You have our information here on the screen. Please don't hesitate to contact us. Let's have one more.
Okay, we already had to cut our hours in payroll. In order to meet the 75% cutoff to get a refund, do we have to force hours to qualify? What time period will be used for calculating this?
Well, Larry, we've kind of covered this already, and there is that's kind of, I presume that's for the forgiveness is what is being discussed there, Carol?
Yep.
I think so, yes.
You know, and again, there's a lot of things that are going to change on that, so I think we'll hold on to that. We're going to monitor that.
It's 8
Here's
weeks.
kind of,
Yeah, it's the 8 weeks from the date the loan is originated.
original date, and maybe I didn't hear the question, and I thought it was more specific.
That's the period.
Okay.
The period, loan starts 8 weeks. That's your
8 weeks after that, yeah. No, there's no doubt. This CARES Act, this PPP is to go for 8 weeks. So you pay your employees for 8 weeks, you have expenses for 8 weeks, you have the costs that are allowed, the insurance for 8 weeks. You know, one of the things we didn't mention, one of the costs allowable expenses in insurance, and insurance includes business liability. That's my understanding as well, Larry. Is that not yours?
Yes,
business liability can be included.
Business liability should be included, but I would want to make sure to run that by your bank before you spend it.
Yeah, and same way with workers' compensation, right? Same type idea.
Absolutely.
Okay, well, I want to thank everybody for listening and for being part of this webinar. We are here. As you can see, there are a lot of caveats. There are a lot of special situations. We are here to help you. We are here to provide guidance. Larry and I, and obviously Jim is getting his infrastructure together. We are going to be helping our clients complete these applications and get them in. It'll be for Payroll Plus. There'll be no fee because we're going to be doing it mainly for two reasons. We have all the data. We want to do what we always do, free you up to go run your business, and we're going to be handling this side for our customers. So I thank you very much for listening. I especially want to thank Larry and Jim. We have been working on this and having discussions over the last several days, just trying to make sure we have our arms around it to level. So Larry, to you, I'm very grateful, Jim as well, and we appreciate all of you. We're here for you, so please don't hesitate to contact us. Have a great day.
Thank you, everybody.